As fans of Vybz Kartel wait with bated breath on the outcome of the World Boss's appeal case, attorney Roderick Gordon is back on our show this week to answer pressing questions surrounding the case. You may remember Roderick saying this to us about the verdict last year.
I don't want to put a number on it, but I would think 8-10 months.
And now, after over a year of review, some of the big questions some are asking are, why is the decision taking so long? Could the adjudicators be awaiting the conclusion of the juror corruption case before reaching their verdict? Sir Gordon, sir, thank you.
Certainly.
Welcome back. And thanks for coming again and to help us with this.
My pleasure.
I'm sure you would have been aware of the fervor out there about a decision now.
Let's start at the issues that go into coming to a decision in a matter that's heard before the Court of Appeal. So the Court of Appeal schedules the hearing of an appeal. 3 judges of the Court of Appeal hear the appeal. Mm-hmm. Okay? So you have the appellants. In this case, I think there were 5 or 6.
Yes.
And you then have the transcript from the original trial. Now that transcript, I gather, is over 10,000 pages. Ooh. And so what you're saying to a court where you're complaining about the quality of the evidence given and decisions made on evidence is you have to go back and look at that transcript at the various points to see how those decisions were handled.
10,000 pages.
That's just the transcript. That's just the transcript. That's not the authorities yet. So when you go to Court of Appeal now, any issue in the appeal, any ground of appeal, any legal submission, you have to have cases that support your position.
Yes.
You can't just go and say, well, the phone was tampered with, and we have evidence that the police admitted they made a call on it, so throw it out. No, you have to bring other authorities that have been decided either by the Court of Appeal in Jamaica, other courts, other jurisdictions in the common law, we call it, or anywhere else in the world that may be relevant to support your position. So you imagine, Winford, that you have, let us say, 15 grounds of appeal.
Yes.
You then have your legal submissions, which are written submissions, which is another volume. And you then have the authorities or the cases to support those submissions. So each judge, realistically, could be looking at 15 to 16,000 pages that they have to go through. So this is literally like Game of Thrones seasons 1 to 8. So put aside the personalities. The court takes its obligation very seriously to deprive a citizen of his or her liberty.
Yes.
And in a case as serious as this, they have to ensure every page that is relevant is looked at.
Hence, you said last year when people were thinking that there could be some decision in 3 months or so.
Yes.
In fact, some expected it from last December.
Yes.
And you said, you cautioned everyone, and you said it could be 10 months.
Right.
And it's even more than that now. It's over a year.
I want to make one other point on time, which is important.
Yes.
I said before that it's 3 judges who sit and hear the appeal. Each judge has the authority to write their own judgment. So imagine that we're not just talking about over 15,000 pages of transcript, nearly 3 weeks of oral hearing, but you now have 3 individuals who go back, who have other daily schedules, to now go and consider to write their judgments. Before we move, there's one more important point. You remember we discussed the last time about fresh evidence being admitted at the appeal stage. So there were complaints that the manner in which the trial judge considered the question of the tampering, the alleged tampering of the jury, was unorthodox.
Yes.
And what some of the appellants have argued is that the accused's constitutional right to be present when matters concerning him or her are being considered by the court, that was breached, because the considerations went into the judge's chambers. He invited counsel from both sides in, from the DPP's office and the defense counsel. but the actual accused was not present.
Excluded.
Yes.
Oh, so that was a breach of procedure?
That is one of the grounds of appeal.
Okay.
So I'm saying that because that is an added legal issue that this Court of Appeal has to consider apart from how the trial on the facts dealing with the murder of Lizard and
yes.
The conduct of whoever was involved in this heinous act. And that's an additional legal ground now that the court has to now go and consider.
And the juror case.
So the juror case now,
Yes.
and I have heard people asking, that case has started, there has been evidence given, there has been coverage in the media speaking about allegations of the quality of that material, okay, that things seem to have been tampered with.
Yes.
So the question is, how does that impact
The case.
the appeal?
The appeal,
The
right.
appeal case. So technically, this court has heard the appeal on the evidence that was available at that time. What we currently have going on in the parish court is a trial concerning the alleged bribery of jurors who sat on that jury, but we don't yet have a decision.
So the allegations
Yes.
of tampering with editing material
Yes.
and so on,
Yes.
those are just allegations?
They are still just allegations. And the same way in which I think Sean Storm's lawyers in the appeal applied to enter fresh evidence
Yes.
is the same procedure they would have to follow now if there were some material out of the juror's trial
Yes.
that they felt impacted the appeal. So you would now have to apply after the appeal hearing has been closed for over a year to say that there is compelling...
Reopen it.
Well, effectively. Because what you're going to now say is there's compelling fresh evidence
Yes.
that wasn't present at the time, either that the trial was heard or at the time the appeal was heard, that we still believe is relevant to the deliberations of the court before they come to a decision. So the court itself cannot simply say, okay, we're going to watch and see. The duty would be on the accused and their counsel if something arises that they feel that compelled to make a new application.
But hasn't that been made?
Not
The defense sounded,
yes.
they sounded as if they're very comfortable, very confident
Right.
that they have something that could push a review of evidence.
Yes.
This particular tampering of this issue of tampering with the evidence.
With the recordings in the other trial.
So wouldn't that be done?
Well, I can't
You can't say whether it's done.
I can't say. But what I'm saying is that would be the procedure. So it's not just that it is
But
happening.
they would have to action it.
Absolutely. Absolutely.
All right. So, what if there was a verdict from the appeal court
Yes.
and this came after? What would
Yes.
happen?
Great question. So it depends on what the verdict from the Court of Appeal is, because currently the prosecution would have no right of appeal. What potentially could happen, depending on the impact of that decision on the ruling one way or the other, is one could then seek to appeal to the Privy Council.
Okay.
And at that stage...
Final court now.
Exactly. And at that stage now, you would introduce this fresh evidence or this new decision, which was not before the Court of Appeal when they...
So the Supreme Court couldn't reopen the case?
No, the Court of Appeal, not by themselves.
How credible does it look in your community, in the legal community?
Yes.
What are your cohorts, your lawyers saying about this? This evidence that is now brought forward, or this allegation?
Well, yes. As you know, Winford, we really don't comment on matters that are before the court as live matters. So I wouldn't want to express any view or any observation on whether it is credible or not, or what the feeling is in the community.
So do you want to make a prediction another one about the timeline.
The timeline.
Given all of what you now know.
My own judgment would say we would be looking more towards maybe Easter next year. Would be what I would think based on what I now know.
Christmas is possible.
Christmas is possible.
Roderick, sir, Mr. Gordon, thank you so much
My
for coming
pleasure.
and sharing with
My
us.
pleasure, Winford.
Yes, sir. Well, you heard it right here on our stage from the man who knows so much more than any of us about this case, Mr. Roderick Gordon. So it may be next year, Easter, maybe Easter for those fans of
That
the...
is the next, to be clear, that is the next end of the next court term.
Okay.
So that is why I say Easter.
Oh,
Okay,
the
there
end
are
of the
3
next
terms.
term.
You have
Okay.
end of Christmas, December, right before Easter, and then you have the summer term. So that is why I'm suggesting that.
Okay, so it may be Easter, but Christmas is possible. All right, stay with us. Still to come right here on stage.